Tennessee is now in session. God save the United States, state of Tennessee, and this honorable court. Be seated, please.
Good morning and welcome to this Scales Boys State program. And the Supreme Court, under the leadership of former Chief Justices Riley Anderson and Al Birch, has committed itself to being a visible and accessible court, not a court which is confined to an ivory tower in Nashville, but one which is committed to going throughout the state and hearing your voice. The Scales Project stands for Supreme Court Advancing Legal Education for Students, and it creates a partnership between the judiciary, the bar, and the students to promote a better understanding of the judicial branch of government. If you would call the first case.
Gary L. West and Mitchell B. Richardson versus East Tennessee.
On September 2nd, 2005, the Tennessee Supreme Court issued a landmark decision, Gary L. West versus East Tennessee Pioneer Oil, that expanded potential liability in sales to inebriated customers. And I quote, "Tennessee businesses selling products to visibly intoxicated people are subject to more liability." The court found that a convenience store had a duty not to sell gasoline to an inebriated customer who later was involved in a head-on collision. This landmark case is the basis of this true story that led up to this decision. On July 22nd, in the year 2000, Gary West was traveling northbound on U.S. Highway 11 West in Knox County, Tennessee, in the dead of night. On that exact same night, and exactly at the same time, on the very same road, U.S. Highway 11 West, Brian Lee Tarver was driving southbound in the wrong northbound lane. Tarver crashed head-on into West automobile, causing severe personal injury and property damage to Gary West. Just minutes before the accident, Tarver had been a customer at a gas station's convenience store located at 7606 Rutledge Pike. Pioneer Oil was the owner-operator of that store. The store clerk, employee Dorothy Thomas, testified on the night of the accident, Tarver was visibly drunk and staggering while at the store immediately prior to the accident. She refused his drunken demand to buy beer, but she did choose to sell the same very drunk Tarver $3 worth of gasoline. After buying the gas, Tarver was so drunk that he couldn't even walk out the store's door properly. And more importantly, not only did he stagger to the pumps, but he couldn't even pump the gas into his car. Another employee, Candace Drennan, actually had to help him pump the gas because he was too drunk to figure out how to do it himself. Miss Drennan then watched as Tarver drove away going southbound in the wrong lane of traffic without his headlights on. At no time did any of the gas station's employees attempt to notify the police of Tarver's actions and his obviously intoxicated state. Today, the Insider Exclusive goes behind the headlines to meet Greg Coleman, partner at Coleman and Edwards, who successfully took this case all the way to the Tennessee Supreme Court to fight for and get justice for Gary West, and to the actual Tennessee Supreme Court hearing that unanimously found that Pioneer Oil could be liable both under a general negligence claim and a claim for negligent entrustment. Simply stated, the court said the defendant convenience store owed a duty to act with reasonable care under all circumstances. And they continued, under the facts of this case, we conclude that the acts of the defendant in selling gasoline to an obviously intoxicated driver and/or assisting an obviously intoxicated driver in pumping gasoline into his vehicle created a foreseeable risk to persons on the roadway, including Gary L. West. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from Knoxville, Tennessee, at the law firm of Coleman and Edwards. It is my great privilege to introduce Greg Coleman of the law firm of Coleman and Edwards. Welcome to the show.
Thanks, Steve.
This is an amazing case, this Gary L. West case, because it's another example of how you, as a very good lawyer, are able to hold corporations and businesses responsible, and so they don't kind of weasel out of their duties of caring. Tell us a little bit about the Gary L. West case. Tell us about the facts.
Steve, it's an interesting case from a factual standpoint. Gary West was traveling on a 4-lane, but in a rural area outside of Knoxville, when a drunk driver coming the wrong way in Mr. West's direction around 11 p.m. at night, without his lights on, crashed into the front of the West vehicle, causing all kinds of damages both to the car and obviously to the occupants. And so it's one of those cases where you think, it's just a drunk driving case. We see those every day, all day. What makes this case different? Well, the fact is the convenience store, East Tennessee Pioneer Oil, did not sell him beer, but because he was so drunk, they sold Mr. Tarvers, the person driving the car that struck my client.
Right.
They sold him gas. Not just that, they went and pumped the gas for him because he was so intoxicated he couldn't do it on his own. And so that's how the case sort of originated.
There were certain facts that were disputed on both sides.
Right.
And because of these facts, well, some of the facts weren't disputed. A guy showed up at a gas station, he was drunk, they refused to sell him beer, but they sold him gas. He got in his car, he couldn't even pump the gas himself.
That's correct.
He got in his car and he drove off, and the people that pumped the gas for him were actually employees of the oil company, the gas station, but happened to be off duty and happened to be still in their uniforms and happened to be on the property and happened to assist the drunk driver,
Right.
Tarver, in pumping the gas because he was incapable of doing it himself.
Right.
So some of the issues that come up are these liabilities issues, these negligence issues. And for our audience, can you talk a little bit about negligence per se, negligent entrustment, and the issues that you brought up?
Yeah, Steve, the way this works is, and it's not just Tennessee, but these laws are fairly similar throughout the country. Everyone has a duty of care as long as that duty, if you can show, has been breached. In other words, well, what did the convenience store do wrong? They didn't sell him beer, they sold him gas.
Yeah.
But they went further. They affirmatively helped him out the door because he was too drunk.
Because he couldn't open the door.
He couldn't open the door.
Yes.
They went out to the pump. He was too drunk to pump the gas.
Well, you bring up an interesting point. The clerk in the store did not go out to the pump.
Correct.
But when he went out to the pump to pump the gas, he couldn't do it. There was a buzzer that went off in the office.
Right.
And the clerk who was on duty, the employee that was on duty, asked the other employees who were off duty to go out and see if they could help them, right?
Exactly.
And that trail is important, isn't it?
It's very important.
Because you had an employee asking another employee who is off duty, but they're acting on behalf of the corporation on the property using their own equipment, right?
Exactly.
Now, the oil company's counsel stated that they were not responsible, right?
That's exactly.
For off-duty employees. But they really didn't tell the whole story, did they?
No, because like you mentioned, Steve, if you're doing something and it's for profit, the gas was there to be sold. It was there to be pumped. And in this case, instead of, it's different when someone affirmatively acts under a negligence scenario, where someone affirmatively does something versus someone who just goes, I'm not going to do anything, and watches a person do whatever they're going to do. That was the difference in this case.
Yeah, we have a rare treat today. We have the actual video footage of the Tennessee Supreme Court hearing on this case. And we're going to go to portions of that in a minute. But what I wanted to bring up was when you talk about duty, responsibility, everyone owes a duty to society, to themselves, to try and protect it. There was one instance, I believe, in the court hearing, where I think the question was asked, was the employee or anybody in that gas station responsible for taking the keys away from the drunk driver, Tarver, or wrestling him to the ground? And the answer to that is no, isn't it?
That's correct. No, the duty doesn't extend that far.
Right.
The duty is once you do something, once you put something in motion, like pump someone's gas, or help them in the car and watch them drive off the wrong way without any headlights on at 11 o'clock at night, well, you've established a duty by those actions.
Yeah, when I watched, and we're going to watch this in a minute, but when I watched that Supreme Court video footage, I thought to myself, what if they were selling guns in the convenience store? Because they do sell probably in Texas, right?
Right.
And they refused to sell this guy beer, but they sold him a gun. And they sold him bullets. And he went outside, but he was so inebriated that he couldn't put the bullets in the gun. But an employee would help him put bullets in the gun. They've created the same dangerous situation, haven't they? Essentially,
and that was one of the questions that the Supreme Court was interrogating or quizzing the lawyers about. What's the difference?
Exactly.
Put a potentially deadly weapon, a car, into motion, whereas the evidence was, Steve, but for the purchase of that $3 of gas by Mr. Tarvers, he never would have made it to the accident scene.
Yeah. Every story has three sides to it. Your side, my side, and the truth. Right. So we're going to go right now to Gary Duplar, who was the counsel for Pioneer Oil, and this is the actual Supreme Court footage, and he's going to explain the facts of the case. So let's do that right now.
May it please the court, my name is Gary Dupler. I am from the Knoxville Bar. I, along with my colleague, Clint Woodsman, represent the appellant defendant in this case, East Tennessee Pioneer Oil. Let me say first of all that it's an honor to appear before your honors, and it's also a double honor to appear here in the Scales program before the Boy State delegates. We are here to present this case along with our colleagues from the Knoxville Bar who represent the plaintiffs. Appellees, Mr. Greg Coleman and Mr. Mike Myers. I would ask on the front end, your honors, that 10 minutes be reserved for rebuttal. Plaintiffs' appellees, because they were the original non-movements. Facts go like this, your honors. July 22nd, 2000, it's a Friday night, late in the evening, a drunk driver comes into the Exxon convenience store owned by East Tennessee Pioneer Oil. That man's name is Brian Tarver. Obviously, he is not a defendant in this case. He never has been. But in any event, he comes into the convenience store. He's driving a 1985 Olds Cutlass, pulls up to the gas pumps, goes into the convenience store, and asks for beer. That sale of alcohol is refused. He then asks for gasoline. Wants $3 worth of gas and throws $3 on the counter. He then exits the store, goes out to his vehicle. There again, the facts most favorable to the plaintiff. We've got two.
Yes, excuse me. The facts reveal whether or not it was necessary after you say threw the $3 on the counter. Did the clerk have to turn the pump on at that point, or was the pump already on?
Yes,
is there anything in the record one way or the other?
There is in the record. There are depositions in the record from the clerk, one in particular, that the clerk had to push a button inside the store to turn the pump on.
Although the clerk had refused the sale of the beer, and I guess it was because he was visibly intoxicated, is that correct?
That's correct under our facts.
The clerk automatically agreed to sell him the gasoline as soon as it cost $3 on the counter.
It's very interesting how he talks about this, the off-duty employee. It was an extremely important point. What do you have to say about that?
Well, ultimately, the Supreme Court said it was not an important point because even though they were off-duty employees, they were still employees, and they were acting at the behest or at the request of an on-duty employee who said, hey, go help this guy. He can't, he's too drunk, go pump his gas for him.
Now, I understand there was some dispute about whether those words were actually spoken by the on-duty employee to the off-duty employee, but the off-duty employee in a deposition stated that they were told to do this, weren't they?
Right, that they were told to assist Mr. Tarvers in pumping the gas, absolutely.
Mm-hmm. We're going to go to that issue when he was talking about the off-duty employee and whether they were an agent or whether they're responsible. We're going to go right to the Tennessee Supreme Court right now.
Two off-duty employees, and that's going to be key in this case, Your Honor. Two off-duty employees.
What difference is that, whether they're on duty or off duty if they're employees?
Well, the Court of Appeals has made a distinction and said that on the specific facts of this case that the fact that our employees went out and assisted this man in pumping the gas is what engenders liability. So, our employees being on duty or off duty is important because of the modicum of control. We lose all control, basically, when an employee is off duty versus on duty. We have some control over an employee who is on duty.
Who had control? I mean, was it this clerk cashier that was in the establishment at that time that was the authority figure?
There's no proof in the record of any manager or any other authority figure. So yes, the clerk would be the employee on duty at the time.
And so was this person aware of the other two store employees that helped pump gas?
She was aware of their presence under the record. What the depositions and what the record shows, Your Honor, is that the clerk pushes the button to turn on the pump on the outside. There's a beeping noise that comes up saying, somebody's out there trying to pump gas, but the transaction has not been completed. And the clerk says, would somebody go out there and help this person trying to pump some gas? There was our off-duty employee sitting in the store at the time, and our off-duty employee hops up and says, I'll go out there and help him pump the gas. So that's what she does. She goes outside. There's another off-duty employee who was outside already, and the two of these off-duty employees go over to the drunk driver, Mr. Tarver, and what the proof shows is there's another button that's on the pump. And what they do is they push that button.
We hear the issue of foreseeability.
Yes.
Tell me a little bit about foreseeability as it relates to this case.
Well, the question for the court, Steve, and that I had to show to the court was the actions of the clerk and those that pumped his gas. Was it foreseeable to a reasonable person that those actions to an obviously intoxicated person pumping that person's gas, was it foreseeable that an accident could happen, especially as you watch him drive off the wrong way without any headlights?
Right.
And the answer was, yes, that's foreseeable.
Right.
Something bad can happen.
Yeah. You also hired an expert to determine the amount of gasoline that was not only pumped in the car, but the amount of gasoline that might have remained in the tank.
Right. What I did, my associate lawyer and I, Mike Myers, we contacted and found out where Mr. Tarver, the drunk gentleman, where that car was in salvage. I purchased the car.
Yeah.
Took the gas tank off the car.
You purchased the car.
I purchased the car.
Right.
Took the gas tank off the car, and we met with an expert engineer from the University of Tennessee and had him examine and measure the gas that was in there. And he opined that but for the purchase of this $3 of gas that was in the tank,
Right.
that Mr. Tarvers would not have made it to the accident scene because he would have wound up a little over a mile short.
Yeah.
And that was a big fact for the court to consider.
Yeah, it was also very interesting because this same expert said that there will always remain some gasoline in a tank that is unusable.
That's exactly right. That's part of any tank. There's always that backflow. And so we were able to show that if he hadn't have purchased or if they hadn't have pumped the $3 worth of gas in the car, he never would have made it. He came in on fumes, in other words. And so that's what caused the accident to occur.
While Gary Duplers is talking about this, we're going to go to the Supreme Court because a justice is talking about this standard of care, the duty of care. We're going to have a clip directly out of it. Let's do that right now.
That your employees, off duty or not, owed a duty to harbor and to foreseeable third parties not to sell them beer.
Because that's set by statute, yes, you're right.
We're talking about duty, right? Why don't they owe him a duty not to provide him with the mobility in a visibly intoxicated state, not to go out and help him, essentially assist him in doing what he could not do, which is not gas, to get in a vehicle in a visibly intoxicated state and go out and hurt third parties on the highway? This is not a person who is unforeseeable. You know, when you get on the highway, there are going to be other people on there.
It pleases me a lot to see that some of these justices, talk about this standard of care, this duty to, for society. I didn't even think about it when I first started watching it, but the gasoline company, Pioneer, had a duty not only to third parties, that means other people on the road, but also to Tarver, the driver, the drunk driver, to not hurt himself. He was included in that third party.
Yes, essentially, although that wasn't a claim that I brought because I was obviously adverse to Mr. Tarver's.
Sure.
But certainly, once you affirmatively do something like was shown to have been done in this case, you've got to make sure that it can be done safely.
Yeah.
And clearly, Mr. Tarver's, in his intoxicated state, was not able to do it safely.
Right. Now, this entire Supreme Court hearing took, I think, 52 minutes or something like that, and each of you were allotted equal time. Somewhere in the neighborhood of 24, 25 minutes.
And this was one of those scenarios, Steve, where the court, at its own discretion, can extend the time because of the nature of the case, and that's what happened here. Normally, we don't get that long per side, but the court had a lot of questions, as you know.
We have just heard from the other side. Now we're going to go to your presentation before the court, because I think more than anything else is, first of all, it's very rare that we can have this kind of footage, but we're going to go to your description of the facts. Let's do that right now.
Good morning, Your Honors. I'm Greg Coleman from the Knoxville Bar as well, along with my partner Michael Myers, who are here today on behalf of Gary West and Michelle Richardson. As did Mr. Dupler, I want to thank the court for the opportunity, as well as the delegates, for allowing us to be here today. Simply put, of course, what we do in these things, we listen to the court ask questions of our opponents to see where the court is headed. I don't know whether that necessarily applies in this case, but obviously the issues in this case concern themselves with 1, negligence, 2, negligent entrustment.
Now that you have discussed before the court negligence and negligent entrustment, what other thoughts could you explain to our audience why that's so important?
Well, negligence, as we talked about, is the duty of care that was owed and the failure by someone to maintain that duty when it applies. Negligent entrustment, Steve, is a little different. In this case, what was negligently entrusted was the gas.
Yeah.
The law used to be in Tennessee that when someone negligently entrusts something, a car, or in this case, gas, the owner had to maintain control.
Right.
Well, this case changed decades of law in Tennessee and overturned previous rulings because, in essence, the court said, look, all that we look at in these cases is, was there a duty? Was there a breach of the duty? The ownership, the continuing ownership of the chattel or of the gas is not the deciding factor as it used to be.
Let me ask you this question. This overturned the whole way of thinking prior to this time.
It did.
How it extended this liability, the responsibility.
It did.
This duty of care. Why do you think at this time the justices now started seeing things, I would like to say, in a better light?
Well, on the negligent entrustment theory, the decision that had been the law in Tennessee for years before had been criticized leading up to this case. And so I was fortunate that I was able to bring this type of fact pattern to the court, number one. Number two, with respect to duty, it helped cement in Tennessee jurisprudence that, look, when you make an affirmative act, when you go pump gas, whatever the scenario might be, you have to do it safely, that a reasonable person won't get hurt. And that's what the court made the decision about in this case.
We're going to go again back to the Supreme Court because there's another issue that one of the justices brought up, which was having knowledge, and you brought it up too. The justice gave an example where he said, what if a drunk driver pulled into a gas station and put his ATM card or put his credit card in there, never went into the cashier's office, okay, activated the pump, pumped gas into his car, and drove off down the wrong side of the road without the headlights on, would the gas station be responsible? And what do the justices say?
What they talk about, Steve, is, you know, how far does the duty extend?
Yeah.
And I said, look, Your Honor, I don't think those are the facts that we are faced with here today. But at some point, the duty of reasonableness does cut off.
Yeah.
And where you've not affirmatively acted, which was the case here, there was an affirmative action. Well, that's a little different. There's a difference in the law, Steve, between misfeasance, which is an action, and nonfeasance, which is sort of a hands-off approach. That's what the court was asking about.
You also brought up a very key word. We're going to go right to the Supreme Court right now, to the video that we have of this, of the word knowledge, whether you know something or not. So let's go there right now.
What duty, if any, would the clerk of the store have?
Well, that's the key, Your Honor. You used the word knows. Tantamount or a part of all of these issues is the issue of knowledge. The knowledge in our case of the clerk that this man was, as she said, visibly intoxicated. She used, if you look at her deposition and her statement, which is part of the record, she used the words wasted, barely in the water.
That's exactly the facts I
That's what I'm saying.
He's already paid for the gas and had already received it before she saw him.
The correlation, the connection between your scenario and this case would be the knowledge. If the clerk had the knowledge, those are things that can be sifted out and brought forth through discovery and all of the other ways that we do those things on a day-to-day basis. In my way of thinking, if the clerk had the knowledge and on your scenario, there weren't all the other factors in this case of helping them out the door and pumping the gas and those sorts of things. So we could make this holding as fact-specific as this court believes it needs to be.
As I mentioned earlier, everybody has their own interpretation of the facts. And I want to present, you at the Supreme Court. We're going to go back here to the video so we can see exactly how you presented the facts and how they differed from the other side. We'll do that right now.
A judicial basis, that is, what upon these facts, just like we do in other theories of law, what upon these facts makes this case fall within the law that we've set forth, within the parameters. In this case, we think the facts in this case indicate that there was a duty owed, there was a breach of that duty, injury occurred, and proximate cause connected the injury to the accident.
The other issues that we talked about earlier were negligence and negligent entrustment. We also have captured that also at the Supreme Court, so we're going to show that.
About what they did. But I think the key of duty and the key for negligent entrustment cases, it all depends upon the degree of knowledge that the person has. We need to prove what the gas tank held and whether it would have made a difference.
Greg, you talked about affirmative actions creating an agency relationship. Talk a little bit about that, and then we're going to go to the Supreme Court hearing so we can see how you presented this to the justices.
Well, as we talked about, Steve, the key point in this case was the affirmative actions.
Everybody involved, helping everybody.
Exactly, and they had knowledge of his intoxication. That was one of the big factors, remember. And so you take the knowledge and the affirmative actions and you put it together and you realize, oh my gosh, at the end of the day, that's what caused the tragic accident in this case. And so we talked with the Supreme Court. I talked with the Supreme Court about that, and they quizzed me fairly heavily on, okay, well, what does this all mean with respect to the agency issue, Greg?
Yeah.
And the answer is ultimately, not that it doesn't matter overall, but in this case, the agency issue was a non-issue because those off-duty employees were still a part of the scene and a part of the accident.
That's correct. Let's go to that hearing right now.
What makes this case more culpable, in my way of thinking, is that these acts, these affirmative acts, is what caused, we believe, what set these things in motion that caused the accident in this case. Two very hurt people. Mr. West, 190 plus thousand in medical. Ms. Richardson, about 16,000, and that's increased since this record was sent to the court. But those are things that I think this court has looked at and evaluated in the scan, that there are certain circumstances where you look beyond special relations or special circumstances, although I believe this case falls within that as well. The negligent entrustment issue, that's one, quite frankly, Your Honors, that I think really needs to be looked at. There is a dispute among the various sections of the courts of appeal as to whether the sale of chattel can constitute negligent entrustment. We had the Raines case that's mentioned in the brief. We've got the Conklin case that's mentioned in the brief. All of these cases that talk about...
The entrustment issue, is it still before us? I didn't think you counted that as...
Yes, Your Honor. It's in the brief, and it's been briefed and talked about, I think, fairly well. And my understanding is under Rule 13, you can consider at your discretion, of course, pretty much anything you want to. But those are the things that I would ask the court respectfully to take a look at as well, because Brown versus Harper Road has been fiercely criticized, which is a Court of Appeals opinion. There is no Supreme Court opinion necessarily on the issue of negligent entrustment. Brown versus Harper Road is a 40-plus-year-old decision that's been criticized both by Professor Keaton, who says that those decisions just look wrong for you to say that a sale of a chattel cannot constitute negligent entrustment. So those are the issues that we have brought before this court for your consideration.
In the end, you know, and I remember when you first got up in the beginning of the hearing and you said, oftentimes we listen to the questions that are being asked to the other side to determine which way the court might be leaning.
Yes.
Okay. Did you have a feeling, you know, as you were being questioned yourself, you already heard the other side, that this case was probably going to be written in favor of you and your client?
You know, I wish I could encapsulate that and sell it on the market, but I did have a feeling in this case.
Just by their questions?
Just by the questions. Now, sometimes judges and justices, I will tell you, it's the exact opposite. But I had an understanding and a belief based upon the way they were asking the questions, that they were at least looking very carefully at what I had to say and what the fact pattern was in this case, because it changed the law in Tennessee.
Right. And the final end of this is the Tennessee Supreme Court held them responsible, didn't it?
They did. Found that there was a duty of care owed by East Tennessee Pioneer Oil to someone that had never been, was not on their premises that night, and was a third-party person on the roadway.
What has been a result of this decision? This is a landmark decision. What has been a result of this decision in this case?
Well, from a personal standpoint, it's been very rewarding to see it mentioned in other cases and law review articles and being cited as authority, not just for cases in Tennessee, but for cases all over the country. And I've often felt, Steve, that the negligent entrustment issue is just as important as the negligence issue, because it overturns so many years of law. And now if you can show that something was given to someone else with knowledge of its danger, that owner or person in control no longer has to maintain control. It's the act itself which requires responsibility.
Does this case get cited in other jurisdictions outside of Tennessee?
Oh, yes.
And do those lawyers win their cases successfully?
It has been, like I say, rewarding. There have been cases in other states around the country and calls that I've gotten from other lawyers about...
Do you have lawyers call you, ask you to handle a case because of the way you handled this case?
That's exactly what happened with this case. The West case was the case that led me ultimately to be contacted by Mona Wallace for the Amanda Satterfield case.
Wow. Little did you ever think that such a drunk driving wreck would turn into something like this.
Exactly. Because we had no knowledge when we first got the case, Steve. All it was, drunk guy having accident with another person, but we took it further.
Yeah, well, you know, our hats off to you. That's why we're here today,
Thank
because
you.
this is a landmark case.
Thank you.
And I certainly appreciate spending time with you. Thank you very
Steve.
much, Greg.
Thank you.
Thanks for watching. You can get more information about our guest and the issues at www.insiderexclusive.com.